Welcome ISD 709 staff. This is a fall recording of a legal presentation with our good friend Amy Mace. We've done this legal presentation a few times over the last years. It's extremely helpful to constantly review legal topics. The landscape changes ever so quickly in special education and school law. So Amy's here today with us. She's done this presentation last fall as well, legal topics. We have a fresh set of new topic ideas, mostly given to us by administrators, special education teaching staff, even gen ed staff as well. So some of the topics we're going to talk about today have to do with K through 3 discipline. We're going to cover some Section 504 topics as well. Subpoenas has recently came up, and it's an ongoing thing that I help support as a director. Our staff at times gets subpoenaed for things, and artificial intelligence, and we're going to cover some recent court decisions. This presentation is fall 2025. We're planning on pushing this out to all staff in one of our upcoming professional development opportunities. We will develop a quiz after the recording today for people needing clock hour certificates to get credit for that, and the quiz will be associated with the presentation. I think I've covered everything, Laura, so now let me turn it over to Amy. Just maybe briefly talk any more about your bio or anything, and let's kick off the question session.
Sounds great. So my name is Amy Mace. I am an attorney that practices in the area of school law, and part of that practice is I do a lot of work in special education law, provided advice to clients, and then working with them on MDE complaints or due process hearings or litigation cases. So, and that is a little bit on my background, and I've worked with Duluth for a long time. So happy to be here and happy to provide some training. I'm going to kick it off with some information on K-3 discipline, because this is an area that really changed in the last few years when the legislature passed a law that provides that students in K-3 and early childhood programs cannot be dismissed pursuant to the Pupil Fair Dismissal Act. Now, there are a few exceptions, and I'll talk about those, but the general language of the law is that a pupil enrolled in K-3 is not subject to dismissals. And under the Pupil Fair Dismissal Act, dismissals include suspensions, expulsions, and exclusions. And so what it means by its plain language is that you cannot suspend a student who is in K-3. And I understand that there has been some differences provided with respect to how that law should be interpreted, but it is very clear when you look at the language, because it says students in K-3 cannot be subject to dismissals. And then it goes on and it says that that does not apply to a dismissal for less than one school day. So if you have a student who halfway through the day is presenting a significant safety risk or concern, or has done something, punched a staff member or a fellow student, that would be, you could dismiss that student for the rest of the day because it would fall within that exception, less than one school day. What you could not do is suspend the student for the next day, because that would be a suspension that is prohibited by the plain language of that law. And when the legislature adopted this, and MDE also has provided guidance to directors, that they're very concerned about excluding young students from school for behavior that is very likely related to their disability. And so they're looking to districts to do, gather the IEP team together, talk about educational programming. Does the student's IEP need to be revised? Do you need more evaluation? Do you need to bring in a behavior person to assist with the team? So they're really looking for districts to problem solve around educational programming and IEP interventions, rather than excluding students from school. And I know, and I share, districts have safety concerns, obviously, regardless of a student's age, related to some behavior. And we'll talk a little bit about the exceptions, but just to, emphasize that what the MDE and legislature are really looking for is programming and educational programming changes rather than exclusion.
And so, Amy, if I might, would you weigh in a little bit about what concerns could arise in connection with dismissing a student in grades K through 3 for several partial days?
Sure. So there are concerns that arise if you see a pattern developing of, this particular kid was dismissed early on Monday, on Friday, and the next week he had 3 early dismissals. And part of the concern, again, is about a pattern developing where you're dismissing a student for disability-related behavior. And again, what MDE would expect to see in those situations is a district calling together the IEP team to problem solve around, what's going on here? Are we implementing the behavior plan with fidelity? Does the student they had a functional behavioral assessment? Do we need to do an evaluation? Are there revisions we need to do to this behavior plan? Are there certain parts of the day that are causing the student to become more dysregulated? Really problem solving around educational programming. And the other concern that can develop is that there are specific requirements for special education students when you reach certain thresholds. So for example, anytime you're getting close to a student being dismissed for, 10 days in a school year, there are, concerns that arise related to that because the law looks at changes in placement, and you have to have parent permission for a change in placement. And I'll talk a little bit more about that. But the concern about these partial days of dismissal is how are you tracking them? For special education students, the law says that a dismissal for less than a school day counts as a partial day of dismissal if the child doesn't receive any special education or regular ed services during that time. And for dismissals that are a partial day, typically a student is not going to be receiving services. So, although not technically a suspension for a gen ed kid because it's less than a school day, for a special ed kid, you have to have a means of kind of tracking how many partial days have they missed. Because if you get over 10 cumulative days, MDE is going to be looking to the district and saying, have you conducted a functional behavioral assessment? Where is your behavior intervention plan? Is the student still receiving a FAPE? Or have you denied the student a FAPE based on this pattern of early dismissals? And so it is something that you should be tracking for your special education students. And if it is becoming a pattern, you should be taking action.
And then what about expulsion or expelling a student in K through 3? Is there any language around that?
There is. And so there are 2 exceptions to the prohibition on dismissing students in K3. One is what we've already talked about, that you can do it for partial days, so less than a full day. And the other is that the legislature did recognize that there may be a need to expel or exclude a K3 student if they present an ongoing serious safety threat to the student or others. But in order to get to that step, you have to have exhausted the non-exclusionary measures that are listed in the law for K3 students. And I just wanted to note, I will be providing some written materials that accompany this presentation. And so, you don't have to be taking real great notes because you will be able to consult with those materials to find these non-exclusionary measures. But I just wanted to quickly note what they are for K3 students. And I note too that the law has different ones for K3 students than it does for your other general education students or older special education students. For K3 students, they include collaborating with the pupil's family, child mental health provider, education specialists, or other community-based support, creating a written plan with the parent that details the action and support needed for the pupil to fully participate in the current educational program, or providing a referral for needed support services, including parenting education, home visits, supportive education interventions, an evaluation if they haven't been evaluated for special ed or 504 services. And so those are also measures that you should be considering when you see that, a K through student is being dismissed from school. You should be looking to those non-exclusionary measures and, attempting them, trying them, determining which ones of those, might be helpful to hopefully prohibit the need to dismiss K through 3 students for a partial day. And so if you were going to move to an expulsion, you would have to exhaust all three of those and then also have that ongoing serious safety threat.
Laura, there's one more topic we were kind of hoping Amy could speak a bit about, and it's the 10 total days situation. Amy, do you want to comment on that? I taught at Denfeld for 10 years, and as I reviewed my kids, ninth graders coming into me, this was 20 years ago, sometimes there was like a pattern of a student missed like half the middle school time, and they just weren't in school, and many of those were related to discipline situations. So talk to us about the 10-day total thing.
Thank you, Jason. Yes. So under IDEA, it is prohibited to suspend a special education student for more than 10 consecutive days. And the reason for that goes back to what I was talking about with the change in placement. There is a court case that stands for the proposition that if a special education student is consecutively out for more than 10 consecutive days, you've just suspended them, that constitutes a change in placement. And change in placements can only be made with parent permission. So for special education, for consecutive days, there is a limit up to 10 days. Now, for cumulative days, although there is not a strict cumulative cap that you can't go over 10 days, the MDE looks at any suspensions that exceed 10 days in a school year with great skepticism for disabled children, because they are concerned that when you give it above that 10 days, that it's resulting in a change in placement. Although it's not automatically a change in placement, what they look at are, how long was the student removed, the length of each removal, the total amount of time that the student has been removed for that year, the proximity of the removals to each other, and the reason for each of those removals, and whether it's very similar behavior. So for example, if you saw a student who was suspended for aggression, for fighting either with peers or for being aggressive towards staff, and they had, for example, a 4-day suspension at the beginning of September, a 3-day suspension at the end of September, and then another 4 days early in October, MDE would look at that very likely and say, that resulted in a change in placement when you got over the 10 days, because it's all very similar behavior. If the student is EBD, it's likely very related to the disability. It occurred in a very short amount of time, and you're over the 10 days. To the contrary, if you had a student who had a one-time significant incident where they got suspended for 9 days at the beginning of the year, and then in May they got suspended for just a couple days for some tobacco violation or some violation that was completely different than what happened last September, that might be a situation where MDE does not think that amounted to a change in placement, assuming there's no other suspensions in between. So, it's a fact-based analysis, but we advise districts, anytime you're over the 10 days in a school year, that's a concern. That MDE would, again, looks at that with skepticism. So you should be monitoring those days. And we advise clients for special education students, you want to kind of err on the side of saving some days at the beginning of the school year, so you have, days left if additional behavior occurs. And again, this is the time where you'd want to involve the IEP team, because perhaps, again, maybe this is not the correct setting for the student. Maybe you need to be considering changes to the IEP, changes to the behavior plan. Maybe you need, outside assistance or consultants to assist the team. So there's a variety of things that you maybe could do to hopefully lessen the need to exclude the student from school.
Thank you.
All right, let's switch gears. Let's talk a little section 504. I'd like to set this up by just saying I'm very passionate about this. My wife and I have a child that benefited from 504 supports. He had a seizure disorder, and early onset, the school was calling saying, you got to come pick up your kid. He was missing a lot of school. But once we got medical support, went to our essential health provider, got some great guidance and medication, it became much more regulated. And just the 504 supports for him made a huge difference. So what can we advise staff about? What are some signs and What should staff do if they see some of these signs in the school setting related to 504 supports?
Okay, yeah, and that was a good example, Jason, because that's really one of the signs sometimes that for staffs that sort of trigger an aha moment about, we should be looking at this student as a potential student who might need a Section 504 plan. And so Section 504 plans are developed for students who have a disability, which is defined for purposes of Section 504 as a physical or mental impairment that substantially limits a major life activity. And the major life activity could be learning, but it could also be, walking, breathing, concentrating, those, other major life activities as well. And so, one sign might be repeated absences. That is should be a question for parents in terms of, why are these absences occurring? And if it's due to some chronic health condition or an anxiety disorder or a need for day treatment or mental health support, those are all examples of, flags that should necessitate some additional discussions among, teachers and the parent and your 504 coordinator in the building. Is this a student that needs to be evaluated for 504 services? Other sort of signs are, if you're ever considering retention of a student, if you have a parent or a teacher or a student who is really expressing concerns about their ability to do their work or their ability to their focus or their health. If you have a student who has, failing grades, inability to progress through the general ed curriculum, if they don't qualify for IDEA services, but you think that student likely does have some sort of physical or mental impairment, you should be assessing them for a 504 plan. That's a very common one that, staff are familiar with. If they've, missed school because they've been placed in a day treatment program. Those are ones we've had MDE complaints about where the parent is like, clearly you should have recognized that my child had a need. They missed so much school because they were going for mental health support. And that might be an IDEA evaluation, but if they don't qualify for IDEA, it could be a 504 evaluation. So those are some signs, Jason, that staff should look for.
Let's keep going. We have a lot of other types of plans, like individual healthcare plans. What if a student has an individual healthcare plan for like a peanut allergy? Does that have to be a 504 plan as well?
It does. And OCR in recent years has been very active in this area about why you need a 504 plan. And the reason is that 504 provides lots of rights for, not lots, but provides rights for parents, right? They have the right to receive a FAPE under 504. They have procedural rights. They have the right to participate. There are requirements related to evaluations. So OCR's position is that if it is a student who, like with a peanut allergy, they have an impairment that substantially limits their major life activity of breathing, when they happen to come into contact with peanuts, that is a disability. And so if they need accommodations or services in the school setting because of that disability, it needs to be in a 504 plan. Now, you may have a health plan too, but what OCR would say is that there's no law that governs individualized health plans. You don't have any rights related to an individualized health plan. I can't point you to any Minnesota statute to look at for your procedural rights. So that's the distinction, is that OCR would say, yeah, you do need a 504 plan if they meet the, definition of disability and they need some type of services or accommodations because of that disability.
Great suggestions, especially the paperwork part of it. Let's go further on the paperwork part. I know for IEP services and evaluations, we have to get parent permission. They have to sign before we start anything. Similar for 504 plans?
So for 504 plans, you do need parent permission in two situations. One, for consent for the initial 504 plan, and two, for consent for the initial evaluation. And another thing that commonly, 504 is why it's more difficult for staff in some ways and districts is because you can't look in the law and see some of these things written down. For example, prior written notice. If you look at the law, you won't see anything in 504 that talks about prior written notice. Whereas if you look in IDEA, you will find a whole section that says prior written notice and explains what's required. That said, MDE has said that 504 has a notice requirement, and parents do need notice. So we advise clients for in the same circumstances you provide prior written notice for special ed kids, you should be doing for 504 kids. So when you're proposing to evaluate, when you're proposing to a new Section 504 plan, if you're proposing a significant change to that 504 plan, that's when you would need those prior written notice. One distinction with 504 is that you don't need parent consent to make a change to a 504 plan. And that's very different because for IEPs, you can't change the IEP without the parent's consent. You can't move on to a new IEP. That's not the same with 504.
Okay. One of the most complex things that I've heard over the years is the question about, do you have to have like a doctor's report in order to get the 504 plan? Can you talk a little bit about that, of parent documentation to bring to the school, or can they bring anything to the school?
So that is a complicated area, Jason, and one that, again, there's been some court cases on that helps define the law, because otherwise, again, you're not going to find these answers if you go look at the law. So under 504, there's been guidance from the federal agency that's in charge of it that you do not necessarily need a medical diagnosis to determine a student is eligible for 504 services. Oftentimes, parents will come in with an ADHD diagnosis or some anxiety diagnosis, some type of diagnosis, and they're happy to share it with the school staff. Other times, parents are resistant to go into the doctor to get a diagnosis, from sharing with the district any medical information they have. And districts can and should provide a release to the parent, ask them for any medical information that would be helpful for the team to know. And I always advise, even if you know that they're going to say no to you because they've indicated, no, you're not getting anything from my doctor, put it in writing so that you've put the invitation out there, you've put the release out there, and then you have it in writing that they are, declining your efforts to get additional information that you may need to do an evaluation. So then the question is, what do you do if you don't have medical information? And there's two options. If it's a situation where the team feels we can determine that this student has a physical or mental impairment without any medical documentation, you can go ahead without it. However, there are situations where teams are like, well, yeah, I think they probably have some mental impairment related to attention or focus, but I don't know what it is. I'm not a doctor. I can't diagnose this child. That's not my role as a school staff person. You actually may need to, if you feel that you suspect they have a disability, but you need more information to confirm that, then districts actually have an obligation to propose a medical evaluation. And this is a very rare situation where a district would do this, but I have had a few of them in my career. And this is a situation you definitely want to bring a supervisor in to navigate this, because it's so unusual, and it involves really kind of going into an intrusive area of a family's life, to actually propose a medical evaluation. And there are different ways you can do that. Districts can contract with a doctor for evaluation purposes. A district could offer to have the child's doctor do it, as long as that information is going to be shared back with the district if they do pay for the evaluation. And a lot of times, if a parent believes that the district is going to go this far as to wanting to seek medical information, either they become more cooperative with the district in terms of seeking medical information, or they just decline your evaluation because they're not interested in it. But districts do have that obligation, and there are some court cases where districts said, well, we tried to get the medical information, we asked for it, parents wouldn't give it to us, and the court said, well, you have an obligation to do child find, and if a medical evaluation is part of that child find, you have an obligation to propose that.
All right, let's switch gears. This has been a fun experience so far. I hope everybody's finding it as engaging as I am. I like to know the details. Subpoenas, staff getting subpoenaed is a hot button topic. It comes up every year. Most often it's related to maybe a custody or child custody arrangement. And what should our staff do if they receive a subpoena?
Good question, Jason. Can I add just one more thing on the 504, just because it's
Sure,
on
yeah.
mind, and I think it might be helpful for staff. I just was going to mention too, in terms of sometimes staff get presented with a long list of accommodations from a doctor, from a parent who wants a 504 plan. And they struggle with, what are our obligations related to this doctor's note and these 25 recommendations that they want in the 504 plan? And I just wanted to remind staff that you need to always go back to what the standard is. And this goes for IDEA too. But the standard is, what does the student need to receive a FAPE? And for Section 504, FAPE is thought of as the services or aids that a student needs to meet their individual needs and access their educational program similar to their non-disabled peers. So they might need extended time, or they might need something read to them, or they might need some sort of organization system or assistance with organization. The real thing that the teams need to do when they get recommendations is think about them based on the individual needs of the child. Some kids need extended time, some don't. And a lot of times those recommendations are just a boilerplate list of ADHD recommendations that the doctor has not taken the time and doesn't know what the student's individualized educational needs are in the school. And the concern about just writing all those things in is that, then the parent gets very upset when you try to take them back and you realize, well, the kid doesn't need this. They never use this. Why'd we put this in there in the first place? So being very mindful of what you include in a 504 plan. And the other thing is that it can really set gen ed teachers up to not implement one of the 25 things if there are too many things in that plan. So being very mindful as a team about, what does this student need based on their individualized educational needs? Okay, that's all. I just wanted to add that.
So let's turn over to subpoenas now. What should staff do if subpoenaed?
So if subpoenaed, you should contact your supervisor because there are a number of things that might be in a subpoena that it could be improperly served on you. So one of the first things that the supervisor will do is, work with whoever is appropriate to figure out, is this a proper subpoena? Do we have reasonable amount of time to comply with it? Was it personally served to you, or did they serve it to you in a manner that's not recognized by the law? And then districts have obligations related to subpoenas, and I'm kind of jumping ahead, Jason, but to provide FERPA notices, which is under the Family Educational Rights and Privacy Act. The law provides that if a district receives a court order or a subpoena and they're going to comply with it, they need to provide the parent with notice of that. So if the parent wanted to try to go into court and stop that, they would have time to do that. So by alerting your supervisor, you can ensure that the district, you were properly served, that you have a reasonable amount of time to comply, and that you get those FERPA notices out. And there are actions that districts can take. If it wasn't properly served, or it wasn't, if they want you to appear tomorrow and you're going to be, in the hospital tomorrow having surgery or something like that, there are ways that districts can assist if the subpoena is not a reasonable request. So, but making sure you timely get to your supervisor with that, because usually there are quick timelines with subpoenas.
You helped us with a case in the fall where our staff were emailed in very official documents, but that's an example of not being served appropriately, right, Amy?
It is. So you do have to be personally served with a subpoena unless you waive that type of service. So, and personal service means they, either leave it with, come to work and give it to you personally, or leave it at your home with an adult of, reasonable age. And so, making sure that service is appropriate. And the other thing I would say to you, though, is don't just ignore a subpoena that you get by email now that you've heard that that's not proper service, because you want to note your objection, because you don't want to not appear in court when people think you're going to be there, because that's not a great idea either. And so, for example, in that case, I worked with Jason and I contacted the attorney in that case and told them, we're asking you to withdraw these. These were not properly served. We're not consenting to service in that manner. And we worked it out. Eventually a couple of the staff members were properly served. And sometimes staff do need to, go testify. But it's so Yep. But that's an example of where, and we often have people who are emailed subpoenas because it's the easiest way to do it.
So you've covered a lot of ground there already. We, the district, has to inform the parent. Those letters typically come from Laura or I, telling the parent that we've had a staff member that's been subpoenaed. Oftentimes, the lawyer is looking for a credible witness, and they're looking for somebody to probably mistakenly say the dad's a mean person and the mom's good. And what should our staff do if they're testifying, and what is their responsibility once subpoenaed to testify?
Good question. So just to back up one step, because I haven't made this clear yet, is that you can get a subpoena for two different things. You can get one for documents, and you can get one for testimony. And both of them, still require the FERPA notice, and you still want to, alert your supervisors to them. But just so you know, there are two different types of subpoenas you might run into in your career. The subpoena to testify is an exception to your ability to disclose private educational data, because typically you can't disclose private educational data without the parent's consent. A subpoena, however, allows you to do so once you get to court. But that's another important caveat to that, because attorneys, myself included, would like to prep our witnesses before we get to court, because witnesses feel more comfortable if they can understand what they're going to be asked about and, have sort of an idea of how this court process works. But unless you get the parent's permission to speak with their attorney, you cannot talk to that attorney and prep for hearing until you get to court. Now, you could talk to the attorney, and the attorney could tell you, here's the questions I'm going to ask you, but you wouldn't be able to respond to those questions like, well, here's what I'm going to say about, the student's behavior in school, because that's private educational data, until you get to court. So that's one piece to remember. And then, one of the things too, when we get subpoenas that aren't properly served, is we do kind of impress upon the attorney that we'd rather not be involved in this, right? That staff don't go into education to testify in court on behalf of one parent or the other parent. That this, we want our staff to be in classes with students and not going to court. That said, sometimes you can't get out of it. There are court cases where it is important for people who know the child to testify. But what you want to remember is just to be objective, to rely on facts, things you observed, and try to stay away from opinions, although that may not always be necessary. A judge may have, if they ask you an opinion question and no one objects and the judge is looking at you to answer, you might have to give your opinion. But usually they're asking for you to really stick to, what happened on this date, how did the student behave, what was their response to a particular incident, how are their grades, how do they perform at school. Usually it's more in the wheelhouse of staff members in terms of what happened.
Amy, I'd like to switch to artificial intelligence if we could. It is a new hot topic in schools, and it is revolutionizing both how we do our work and how our students are performing in school. How can you give us some examples of how AI is affecting schools to date based on some court decisions?
Sure. So this is an interesting area of law, and an interesting area that we're all going to be grappling with in several years to come. But there have been some early court decisions that do involve students. So I'll just give you sort of a flavor of where those are, what kind of cases you might see. And then I'll start there. So there was a court case that involved a junior in high school who was a good student, had used Grammarly on an assignment, so some AI to help with developing ideas and then actually, writing part of the assignment. The student handbook clearly prohibited the use of AI. And what happened is the student, had to serve some detention, got a 0 on that assignment. And the parents were very concerned about how this was going to impact college applications. And they wanted this off of the student's record. They wanted credit for that assignment. And they wanted, their argument was that you have a constitutional right to an education, and you have due process rights associated with that constitutional right. and they were arguing that the school district violated the students' due process rights in its investigation and consequence handed out related to this, allegation of cheating. And what the court said is that although there is a constitutional right to an education, they looked at what your due process rights are related to a suspension and in a short-term suspension. And typically your due process rights are just an opportunity to present your side of the story. And they said, here, you don't have a constitutional right to get a particular grade. And they gave you the opportunity to explain your side of the story. That's all the due process that you were owed. And so the student was not successful in that court case. Similarly, there is an interesting situation with a college student currently pending in the court system, and it could just as easily be a high school student. It was, again, this one, they had used GPT-0, which is a software that looks for the use of AI in student work. And it had triggered that the student had used AI. And so again, this student got significant consequences. He was an MBA student in college, going for a master's in business, and he was a French national. And so his argument to the court, again, is that this should be reversed. And his argument is that this resulted in national origin discrimination because there is evidence that this particular AI detection device that was used has a bias against non-native English speakers. And so that was the argument in that case. And that court case is currently pending. But that court case does raise some practical implications, which are, one, instead of relying maybe on just one software, there are other ways to consider whether a student has perhaps, it's not their own work, by looking at native files or by looking at the version histories of documents. And that was used in the previous case. They could tell from looking at different versions that there was a lot of information copied and pasted. And, you can get a sense of how long someone may have worked on a particular paper. So, when you think about sort of your AI detection as you get into sort of in the high school level, using some of those to look for AI, kind of thinking about what other checks could we have besides relying on just one AI software database, because we expect, if depending on how this court case goes, that they'll be looking to argue that there's some sort of bias built into those detection systems. And then, I would say another thing that I've seen, for example, is you're going to be seeing a lot of parents that use AI for writing emails, for writing data requests. It's already started where they, using their arguments, they can now, write arguments to you about what the special education law says, and the caveat there is that some of those emails are so long that you might feel like, this is all AI generated. I don't want to read this. But if it's a data request, we have obligations to respond to data requests as school districts. So if you need help, again, contacting your supervisor, like this looks like a data request under the Government Data Practices Act, what do I do with this? But not just ignoring it because it looks like it was AI generated. I think that's going to be a concern with some of these. And then the other concern is that just because AI says the law says something doesn't necessarily mean that the law says what they're claiming it says. We have, I can tell you in my office, I know of situations in our state where people have submitted briefs to courts that cite, wrong cases. These cases don't exist. And so, same thing with these emails. They may have laws that have been repealed, that don't exist, that they made up the sources. So it just creates a whole new can of worms that we, didn't have to usually deal with, parents' emails that now cite a bunch of laws and try to argue what the law says.
And Amy, there are some practical applications to AI. And so as we think about that, how could AI affect a special education teacher's job?
Yeah, so there was one really other interesting case I wanted to talk about. Not that this would happen in Minnesota. It wasn't a Minnesota case. But in this particular case, they had a student who had needs in reading fluency and written expression, and he was 11th grader, and they were sending home take-home assignments for him to do. And what he was returning was way above his, where he was at in terms of abilities, because he was using AI software to write his papers, to correct his spelling and his grammar. And eventually the parents said, you're denying, and the student had a 3.4 GPA. And the parents brought a case arguing denial of FAPE because the student wasn't actually learning and making meaningful educational progress. And the court was, very disturbed by some of the evidence that came out in that case. This was a student whose reading level was at a second grade. Their writing level was measured in less than 1%. And they had trouble consistently spelling their surname. And yet they had a 3.4 GPA in high school. And so, the court said, this makes no practical sense. You're not teaching the student. You may be teaching them to learn, be proficient on their computer, but you're not teaching them. This is a student who has the ability to read, and you're not aiming your instruction and your progress measurements on them actually increasing their skills. So that's a cautionary tale. Another thing that is a cautionary tale is there's, although technology is very useful and we all use it in our jobs, the key to special education is delivering individualized, meeting their individualized needs and having IEPs that are aimed at their individualized needs and unique learning goals. And so, already I sometimes see this in prior written notices that have drop downs or that have, sort of sample languages to use, where I will see when they talk about like other options considered, sometimes I'll see language that says, we considered reducing the student services, but we decided not to do that. And they'll be proposing an IEP with a significant increase in services. And so, from a practical level, it doesn't make sense that you would have considered as a team reducing services when you were going to propose moving the student to a different setting. That doesn't, on a practical level, I don't think really the team really considered that, and that's just an option that, sometimes is used. So really being careful, I think, and I think this is going to get, without caution, has a concern about AI is having all these sort of the ability to have them write prior written notices or at least sample, examples for you. And so it's going to be, again, just ensuring that what you're writing is really specific to the student that you're writing for and based on their individualized learning needs. I think that's one of the challenges that I see coming down with the ability of AI to assist staff in drafting things. I guess another caution would be, and this is something that, as this further develops, that you guys will have to be working together as an administration level and with staff. But there's some data concerns with AI as well, right? Because AI is not going to be able to assist you to write meaningful, goals or objectives or help you sort of think about writing anything unless they have some data on students. And so there's concerns about, how will this work in schools if you feed private educational data into a software system? And who's going to have access to that then? And how is it going to be used? And do you have the consent you need to do that? And so that's going to be another issue that, not just in the special ed world, but that districts grapple with as they think about, how do we, what AI will be helpful in some situations, we expect as well, but how do we manage our data responsibilities with the use of AI?
Thank you. And as we get ready to close today, we always like to hit the interesting recent court decisions. Do you have any recent guidance around independent educational evaluations? What options might a district have when a parent requests one?
So yeah, this is an interesting Court of Appeals case that's going on right now that I wanted to just alert staff to. Under IDEA, parents have the right to what's called an independent educational evaluation, commonly referred to as an IEE, if they disagree with a evaluation that has been conducted by the district. And, whenever you get a request for an IEE, it's important to bring in your supervisor because there are specific requirements that relate to IEEs, such as you have to provide the family with your IEE criteria. And there's, sort of a sample notice that we send out when IEEs have been requested. But under IDEA, if you look in IDEA, you will see two options for when a family requests an IEE. One is to provide it, which then the district has to pay for. And IEEs can be very expensive, oftentimes exceeding $10,000. Or you have to request a due process hearing to defend the district evaluation that the family is challenging, prove that it was appropriate. That is also an expensive option because due process hearings cost a significant amount of money. And if you go down that route, oftentimes families will raise their own issues. And so it won't just be a due process hearing about an IEE. It will be about several different issues. But several years ago, I had a court case where the evaluation was years old. It was over 2 years old. Everyone agreed that the student needed the needs had changed. He needed a reevaluation. And so the court said that the parents, all these years, they had never disagreed with the evaluation. And so to bring up a disagreement with an evaluation that was over 2 years old before the district had an opportunity to do a reevaluation was really not appropriate. And so the court, denied their request. But since that time, MDE also had a court case or a complaint decision, where they agreed, citing that case, that the parents were not really disagreeing with the evaluation and instead were just trying to get an evaluation by their own expert, and that's not a proper function of an IEE. However, MDE has since that time, in a recent decision, ruled that despite the evaluation being very old, over 2 years, the district only has two options: give the IEE or go to a hearing. And this case is now back up at the Court of Appeals for a number of issues. One, which is, are there other options besides just granting the IEE or going to a due process hearing? Does the district have a chance to do a reevaluation? And the other interesting issue that the court will have to grapple with is the statute of limitations under IDEA. There is a 2-year statute of limitations under IDEA, which means that I can't today, on November 6, 2025, bring a due process hearing for claims that happened 5 years ago or 4 years ago. It's too late. I can only go back 2 years to 11/6/2023. MDE, however, has ruled that the statute of limitations does not apply to independent educational evaluations. And so, because in this case, if the evaluation was over 2 years, there's an argument that, you don't get an IEE because the statute of limitations has expired. If you disagreed with that evaluation, you should have brought a claim within 2 years of that evaluation date. And so that's another issue that the Court of Appeals, we think, will be deciding unless they decide the case on other grounds and decide not to grapple with that issue. So that is a pending Court of Appeals case in our state to watch. And I just wanted to alert you that there might be some updates on IEEs.
Thank you.
All right, just a couple last questions, and these are kind of fun ones, I think. Wanted to bring to your attention, Amy, service animals in the schools. And this week I had to give some guidance to one of our school sites about service animals. We have a district policy on service animals in the schools. There's a tremendous amount of statutes, whether it be state or federal statutes out there. And my school team asked me, my family is wanting to put some beefy language in the IEP about service animals. And I advise them not to put anything in the IEP. It's not required. Am I in trouble? Or did I do the right thing?
You did the right thing, Jason. So I'll start with a little bit of legal background, and then I'll talk about why Jason's advice is spot on. There is, under the Americans with Disabilities Act, school districts do have to allow service animals to accompany students to school if the service animal meets certain requirements. So it's trained to do a task for the student based on the disability, and it's housebroken, and it's under the control of the handler. And so in those scenarios, students are allowed to have a service animal at school. That said, whether a service animal is required for FAPE is an entirely different question. And it is going to be a very rare case, and I haven't had the case yet, where a student actually needs an animal to perform a task that a human could perform. And so I'll give you an example of a court case that a colleague of mine really just recently had. This was a case with a student who had autism. They had a one-to-one para at school, and they had concerns with behavior regulation, sensory issues, elopement. All of those needs had been met by the para prior to the student getting the service animal. And so, the para could provide the supervision needed, the support if the student attempted to elope, the redirecting the student when they were having sensory issues and providing different, sensory items to use. But then the family got a service animal, and they wanted the animal to come to school, and then they wanted it to be written into the IEP. And what they wanted is they wanted the IEP to say that staff would hold the dog's leash while the student transitioned through the school, that staff would tether and untether the dog from the student when necessary, and that staff would prompt the student to cue the dogs with commands as needed. And why the district denied this is because under the ADA, the school district doesn't have an obligation to provide a handler. That is an obligation on the family to provide this handler. And many of these requests, in effect related to handling the dog, holding the dog's leash, tethering and untethering the dog, cueing the dog. And the district's argument was that, staff can provide all of these services and accommodations. We do not need to write a dog into the IEP to provide the student with FAPE because we have staff capable of providing these services. And the problem with just acceding to a parent's request to write a dog into the IEP is that could lead to an argument by the parent that the district is responsible for paying for the dog, for if something happens to this dog, providing a new dog, because FAPE is a free, appropriate public education. So if anything is required for FAPE, it's on the district to provide that. So that's what's the harm in just writing the dog into the IEP? The harm is that it's not required for FAPE. And by doing so, you give the parents an argument that now I always need a dog. And in fact, you should be paying for the dog. And your staff should be the handler for the dog. I don't have to provide the handler. The handler's part of the IEP. So there's a lot of issues with including a service animal in an IEP that, may not be, you don't think of right at first blush. What happened in that case is that when they went through a due process hearing, the administrative law judge actually ruled for the parents. She ruled that the IEP, it was a he. He ruled that the IEP was inappropriate because it did not include the use of the dog, and that the dog needed to be in the IEP. The district appealed that case to federal district court, and the federal district court reversed in favor of the district, finding that the IEP without the dog was appropriate, that the assistance provided by the dog in this case was minimal at best, and that the dog's presence in the school was actually often detrimental to the student because it was distracting, and that the dog was not necessary to support the student, particularly because the minimal supports provided by the dog could be provided by district staff. So that was, the district was very pleased with the reversal of that case because we really thought that the ALJ's decision was not consistent with the law in this area.
Great advice. You covered a lot of different topics there, but one of the most meaningful things is make sure you don't put things in the IEP that don't need to be in the IEP because you can never get them out. Parents will never let you remove something like that. Let's birdwalk just a quick second because I've found that parents really do their research related to service animals, and they find out what types of supports students may benefit from a service animal, and de-escalation, calming techniques, being able to regulate emotions. Cats can do that. They're wonderful animals. Can we bridge a conversation about what other animals might be service animals?
You bet. And you'd be surprised by I've had, not for a district client, but I have a chicken support case, as a support animal case in a city case. So there is a whole host of animals that we've seen, monkeys, all sorts of animals that parents might think are good emotional support animals. So the law makes a distinction between service animals and emotional support animals. The law does not allow you to automatically bring emotional support animals to school. So, unlike service dogs where there's specific law related to it, cats, monkeys, those type of things do not fall within the animals that students can bring to school. The one interesting animal besides a dog that is in the ADA service animal provision is miniature horses. And miniature horses can potentially be a service animal that a student could bring to school. And I'm still waiting for my miniature horse case. I haven't gotten it yet. But there are extra rules related to miniature horses than there are for service dogs. So if you ever have a parent ask for a cat or any sort of animal, again, that would be a case to discuss with your supervisor. Because one thing I do caution people not to say is sort of blanket statements like, we would never, ever, ever do that. So if you get a request for a cat, my advice is, even though you know that that's not a service animal, is that you tell the parent, that's a very unique request, and I'm going to have a conversation with my supervisor about that. So that you can have a conversation about, okay, how do we say no to this in a way that makes sense under the law?
Great advice. Well, Laura and I have exhausted our notes about questions we wanted to ask for this presentation. If we will plan on doing future recordings, Amy, so just want to send a message to our staff. If you've got a topic, a question that would be interesting to be able to present to Amy at a future recording, we would gladly receive that. You can talk to Laura or I, send us an email. Today's recording was about 55 minutes. I took a note on our time frame. We'll include a brief quiz because our content for relationship credits need to be about over an hour of content. So we have fulfilled that obligation, definitely, in wonderful answers, Amy, and legal guidance for us today. Laura, anything else to add?
Not today, Amy. Thank you so much. Very helpful.
You bet. My pleasure.